our show is it's going to be unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, oh, I'm just going to JV it. Like, let's just JV it. Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today, so thank you so much.
Well, then that end buyer could come back and say, well, I didn't fully understand that it was subject to.
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I'm blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property that'll be okay. Suddenly, Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody, and welcome to the show. Today, we're talking about why do we estate plan, essential to business organizational structures, why it is that we think and counsel on estate planning. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to like our channel. You can find us on X, Facebook, and YouTube. On all of those platforms, you can find us at the handle @InRem Podcast. That's @InRem Podcast. Also, you can download an audio version of the podcast. Go to Spotify, go to Apple Podcast, or whichever one that you like using. Download the audio version of the podcast. Doesn't cost you anything. You can like it, leave us a review. It helps us out a ton. And enjoy the show. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So my legal update today is basically touching on a topic that's been all over social media recently, which is the new South Carolina law that regulates and or bans the practice of wholesaling. So here this month, the governor of South Carolina signed a law that basically prohibits the practice of wholesaling, but it does it in kind of a unique way. It doesn't just say, oh, well, you can't wholesale. It actually is more laser focused than that, but at the same time, kind of even broader. So it's real weird. But they did a good job in drafting it to try to eliminate wholesaling within their state. And it doesn't give a lot of maneuverability for investors there to actually wholesale within the state of South Carolina. So let me explain. So in defining wholesaling, they don't just say, well, it's assigning a purchase contract. They actually say wholesaling means having a contractual interest in purchasing residential real estate from a property owner and then marketing the property for sale to a different buyer prior to taking legal ownership of the property. So basically, there's three things there that fall within the definition of wholesaling or that make up the definition of wholesaling. So you have to have a contractual interest in the property. You have to market it, market the property for sale, and you're doing it prior to taking legal ownership of the property. So you don't have legal ownership. You just have a contractual interest, and then you market the property for sale. If you do that, you fall within the definition of wholesaling. They then go on to say advertising or marketing real estate owned by another individual or entity with the expectation of compensation falls under the definition of broker and requires a license. So basically it's saying, hey, if you try to go and you market a property with the expectation that you're going to compensate as a result, that's going to fall under the definition of being a licensed broker. Then it goes on to say, okay, well, what happens if you then have a license? Can you then wholesale? And they go on to say, no, licensees, real estate licensees within the state of South Carolina cannot engage in the act of wholesaling or assist with wholesaling. And so basically they've said, okay, here's what wholesaling is. You have to have a license to wholesale. And oh, by the way, you can't wholesale. Licensees can't wholesale. So they basically pulled it under the jurisdiction of the real estate commission there in South Carolina and basically said, you can't wholesale. Now, it does say, and it does have an exception, which says that wholesaling does not refer to the assigning or offering to sign a contractual right to purchase residential real estate. So now everyone's jumping onto that little section saying, oh, okay, well, as long as I'm just assigning the contract and I'm marketing the contract, I can then, close. But how do you, the issue is, how do you market the contract or having a purchase contract for real estate if you don't also market the property itself and explain what you're buying, right? That's part of the whole marketing of the contract, is you have to provide information on the property. Why would somebody want to buy a real estate contract if they don't know anything about the property? And that's where the whole marketing component comes into play. The other issue that you're going to have, even if you could get away with it by just, being very specific on marketing my contract, interest, you don't give the address of the property, you provide very limited information on the property, et cetera. And then once it's assigned, then you provide that information. Maybe you can, skirt it. I don't know. But from a practical standpoint, and I watched a podcast where an attorney from South Carolina was on, and he's a closing attorney, and he basically said, well, that's all good and well, and maybe you could get away with that, but you still have to close the transaction, and you're going to close in South Carolina through a closing attorney. And it was his position that no closing attorney is going to basically sign off and close on a transaction that they deem is violative of South Carolina laws. And so the fact that there's an assignee in the chain there, and there is an assignment, may in and of itself result in no closing attorney wanting to touch the transaction. What's also interesting is this law doesn't just deal with, traditional wholesaling, which we think of assigning the purchase contract. It actually would prohibit double escrows, because in a double escrow, you have a contractual interest. You're going to market the property before taking title. And how do you double close if you're not allowed to do this? And so double closings would be prohibited as well, because you would have to get out there and market the property. So one of the things that this attorney said in the podcast, which I thought was frankly brilliant, is one way around this law would be to actually do an installment contract. In Arizona, we call it agreement for sales. In Wisconsin, where I'm also licensed, we call them land contracts. In South Carolina, I think they call them installment contracts, because that's the language he was using. But it's basically a contract for deed, agreement for sale, land contract, whereby you basically go to the seller, you give the seller generally at some form of upfront, payment. It doesn't have to be much, but you give them some upfront payment, and you agree to pay the rest of the purchase price over a period of time, or within a specified period of time. And it doesn't have to be monthly payments, quarterly payments. It can be, I'll pay you a balloon payment in 90 days or 1 year or 2 years or 5 years. But it's some level of performance whereby that seller will be compensated. Well, that's a recorded deed, not deed. It's a recorded interest in the property. It's not a deed, because the seller retains the deed, but it's a recorded interest in the property, which goes beyond having just a contractual interest. You actually have an ownership interest of the property when that installment contract is recorded. And then if, the seller wants to stay in the property, and you're going to allow the seller to stay in the property, you keep the seller in the property while you go and you basically market the property for sale, because that's your right now as a purchaser under the installment contract. So instead of doing a purchase contract, you do an installment contract. And instead of recording a memorandum of your purchase contract, like a lot of wholesalers do, you record the installment contract, which then gives you more than just a contractual interest. And then you're free to market the property and basically, profit from selling it to a third party buyer. So I thought that was really interesting. Another thing that this may or may not rule out is because the same buyer would be actually taking title to the property. is, can you market if you have an LLC and it's a sole purpose single asset LLC, and that LLC is the buyer under the purchase contract, can you sell the membership interest of the LLC, at or prior to closing to the end buyer? That's still kind of a gray question out there, but potentially something that may or may not be prohibited by the statute. So of course, seek out advice of a South Carolina attorney, competent real estate attorney who can advise you on what this new law means. But it does take a pretty big bite out of the traditional practice of wholesaling or even double escrowing in South Carolina. And investors are going to have to figure out how they're going to adapt and change if they want to, continue to conduct business there in South Carolina.
All right. Thank you, Sean, for the legal update. Reminder, every Tuesday, so it's Tuesday today, we go live every Tuesday, but we also go live Tuesday afternoons at 2:00 Arizona time, and that is for the Creative Finance Collective. What is that? If you're new to the show, not familiar with what that is essentially a group of professionals and or attorneys in the space of creative finance that get together weekly to talk about all things creative finance. We are lawyers from a variety of different states, jurisdictions that approach creative finance from a different set of laws. So we get together, talk about what states are doing with regard to creative finance, what the laws look like, problems that we're seeing, victories that we're seeing, all things that we're seeing that help, one, make our practice better, but help bring value to you to listen and hear about the experiences of others in the area of creative finance. But what we also do is make ourselves available for the hour for questions for you, the audience. So if you have a question, if you've heard about this thing called creative financing or buying subject to, maybe you've watched some YouTubers in the space talking about this, the quote unquote gurus, and you're like, wow, maybe this is for me. Well, we're lawyers that approach it from the perspective of what's legal, how to do this appropriately, how we've seen it done right, how we've seen it done wrong. This is your chance to learn from lawyers in the space. So we're there to take your questions, and we're there for as long as we have questions. So make sure to join us 2:00 Arizona time every Tuesday. Adjust your calendars depending on where you are watching from, but it's 2:00 Arizona time. Look forward to seeing you there. Also, if you have questions for today's episode, as you're watching, make sure to post that question in the chat. We try to get to questions in the final 15 minutes of every episode. So as you think about those questions, go ahead and post them. If we don't answer that question right away, don't think that we've forgotten about it. We're collecting questions until the end. So make sure to post your questions in the chat. We're monitoring them there. All right, so let's get into our topic today. We're talking about estate planning as an essential to business organization structures. So really the integration of estate planning to your business organization structures. And if you do estate planning right, of course, its tentacles are going to reach into all of your assets, business included. But oftentimes we focus on the business side of things in this podcast. So we're going to talk a little bit about that. And with us to discuss the topic is our friend Natalia Ouellette-Grice out of Florida. Natalia, how are you?
I'm good. Thank you, Andy and Sean, for having me here again.
Yeah, so happy to have you. Good to see you again. Natalia is a lawyer with LCO Law in Florida. Tell us and our listeners a little bit about your law firm.
All right. So about half of our practice is asset protection, specifically focused for real estate investors, in which we engage in estate planning, business planning, and the creative use of certain trust vehicles for protecting assets. And the other half of the practice is real estate litigation, title, possession, all those fun things.
All right. Well, I know this is off topic, but the last time we had you on the show, we spoke at length about the Corporate Transparency Act. Since then, the Corporate Transparency Act by one court's been found, and maybe more, but by one federal court's been found unconstitutional. We've had some lawyers on to talk about that. Have you continued to track the Corporate Transparency Act? I know you were kind of, I know you wouldn't say this, but I kind of thought you were a savant when it came to the Corporate Transparency Act. So I'm sure you followed that.
So I've been keeping an eye on it. For now, I mostly track it to make sure that my clients in Florida aren't subjected to any exceeding requirements. Although what I'm paying attention to now, since we're on this topic of estate planning, is the fact that they're thinking about expanding the Corporate Transparency Act to trust vehicles, which is not part of the current law. So that's something I'm keeping an eye out for. And there was actually an open commentary period recently with the rulemaking. So that's something to just be mindful of. There's many of us in the legal field that are going, no way, this is not something okay.
So while the courts are looking to potentially restrict it, the legislature is looking to expand it.
Correct.
Oh,
Yeah.
okay. Well, that makes me sleep better at night. All right. Well, let's get into our topic today. I know we came here to talk about estate planning. So we're going to start at about 30,000 feet, and then we'll kind of narrow focus in and everything else. But for somebody who's just crawled out from under a rock and has joined us today on our podcast here and is unfamiliar with terms, what are we talking about when we say an estate plan? What does that mean for you from the perspective of a lawyer?
So, to bring it down to, like, again, normal terms, it's a strategy. It's a strategy that a person uses to minimize and avoid probate and guardianship litigation if they become incapacitated, and to optimize taxes, estate taxes, trust taxes, and not just the estate tax and gift tax, but the income tax that's associated with having an estate or having a trust.
So that begs the question, and I get this a lot in my own practice, but who should have an estate plan? I often hear, well, I don't make enough money, whatever that means, or that's only for the rich. When they hear trust, they automatically hear trust fund babies, and they think, well, this is for billionaires. Is an estate plan only for billionaires?
No. In fact, an estate plan, I think, is often more productive for people in the middle class. I mean, if you own any sort of real estate, even if it's just one home, if you have bank accounts and you want to minimize the cost of the litigation involved of transferring title of assets to your loved ones, then using trust-based planning is actually going to be far more economical for your family. Mainly because, right, you're not stuck waiting for years, waiting for a court to decide what's going to happen to approve certain creditors' claims and all that. And as a result, you're also going to have to deal with less income tax consequences, because anything that's in the estate that produces income could be your retirement account. All of that's going to result in an income tax return. And if you have to wait for court orders to be able to just disperse funds to pay those taxes, you might be subjecting your family to additional penalties and other costs that you wouldn't have to if you kept your family out of court. So it's often best for this level here, but they don't realize it because, most people hear the estate tax and they think 13 million and change, and they don't know anything at all about estates having income tax liability.
So, all right, we've talked about an estate plan, but what documents comprise an estate plan? We obviously, I think a trust would, but what other documents normally, when people say, oh, I want to do an estate plan, what does that look like as far as documentation?
So when people think of the documents, they might have heard of the word will, they might have heard of, power of attorney, healthcare designations, living wills, which are the instruments that you might use if you have health issues and are in a kind of a persistent vegetative state or something of that sort. And you want to tell people, like, don't resuscitate me or don't subject me to life prolonging procedures. There's also guardian designations. If you have children, you need to be mindful that making sure your children are with the right people. Anytime there's a emergency, whether it's because you're in an accident or you've passed away, right? You need to have those in mind as estate planning instruments. Of course, trusts, and there's hundreds of different types of trust vehicles that you can use, but entities are also a part of estate planning strategies, right? Entities can have buy-sell provisions, they can have drag-along, tag-along provisions, management agreements. All of those are part of strategic estate planning to just keep your family, yourself, your partners out of litigation.
So Sean mentioned the trust. You mentioned the term trust here a couple times. Admittedly, there can be different types of trust, so on and so forth. But a lot of times folks come in my office and probably yours, and they say, I got to have a trust. I don't know why, but my neighbor said, hey, you need a trust. So how does a trust differ from a will, let's say, which is just, your written intention on what you want to have done with your assets. It's a tried and true method. We still have it in the law. What is different with your generic revocable living trust? Why do I need it? Why is that any different than a will?
All right. So great question. So a will is just a set of instructions for a court. It needs to be administered through court. So a will forces people to go through litigation. A will also, needs to be proved. So not only is it something that you would attach to a petition and you'd have to have the original, and it, depending on who witnessed and how it was notarized and all of that, you might have to have witnesses come to the court and be sworn in and say that, yes, this was the actual effective, true original instrument. So it creates all of these additional expenses, a will, and then court approval, and then directives for a court. That's the biggest difference. A trust instrument, so if it's private, doesn't have to get submitted into court proceedings. A trust will, if properly funded, keep all of your assets from having to be litigated for probate. And a trust just has much greater flexibility as to who gets what and when and how, and even what expenses get paid. So it's all about giving people flexibility and control over what they have without forcing them to go into litigation.
The two biggest scenarios that I see that go overlooked, and I think it's because people think, well, I don't have that much, so why would I do it? But the two things, and really regardless of your assets, that scenarios where you should have, in my view, a trust would be, one, blended families, and then two, when you have like minor children who might inherit assets. Can you talk about first blended families and why a trust would be important, and then the importance of having a trust in place for minor children?
Yeah. So first and foremost, blended families are actually the majority of American families now. So blended families is, you have maybe children from a prior marriage, or you're the stepmom, stepdad. And so not everybody's like the original nuclear family. That's a blended family. And you might have preferences for what you're creating as part of your legacy going to your children directly, and maybe only to your spouse as like a lifetime income provider, but not something that would go to like the heirs of your spouse or the children of your spouse if you're part of a blended family. So trust instruments are really the best way to achieve that level of control and generosity and understanding of the different roles that people play in blended families. And then, of course, if you have minor children, we all know, right? If somebody turns 18, they don't magically get granted the wisdom of an adult. And so if you're creating, real estate businesses, a real estate empire of your own, the last thing that you want is for your 18-year-old to be handed all the keys, which is what would happen if you didn't have a trust-based estate plan. And then within weeks or months, it could be gone. And I literally do mean weeks. I've known individuals who turned 18, they had close to $100,000 that they inherited, and 2 weeks later they were back at step-parent's door because it was gone. There's no provisions protecting them for that money. So vulnerable young children, I would say, are absolutely a key. But I mean, I think it's big for business owners, because what people don't realize is when you pass away and if everything's held in your name individually, those things they get frozen, right? They become frozen assets.
Right.
And that freezing effect impacts your business partners, impacts your clients, it impacts the closing that was going to happen. And so it really is important to have it set up in a way that somebody immediately can succeed that role, like a successor trustee, and not have to worry about none of the assets being accessible, none of the business activity just all of a sudden coming to a halt and waiting for months and months for a judge to decide what are you going to do.
So let's dive into that. I know it's a little further down in kind of our outline here, but let's dive into that as far as the ramifications on a business, because a lot of our clients come to us and they want this elaborate business structure and things like that. And I say, okay, well, what about the top? Like, what's the succession look like? And what about an estate plan? Oh no, we don't need that right now. I'm like, well, you do. So let's talk about what it looks like if, let's say, I personally, just me individually, I don't have partners or anything. I own a real estate empire. I'm at the top, my name only, no trust, no anything. And let's say even hypothetically, I die without a will. What happens? Like, and I have properties under contract. I have, escrows. I have this, I have that. What does that mean for the business?
So I'll give you an example, as if they were a Florida real estate investor, just to give you kind of like the process here, which is very similar in most other states, right? So first of all, somebody is going to have to raise their hand to say, like, I am willing to take on the responsibility and the role of administering this massive empire that was left behind with absolutely no guidelines. And the way that they're going to do that is they're going to have to petition the court to say, this person passed away. Here's proof of, they passed away. They owned these things, as far as I know, right? Because that's the other issue. They don't know what you own if you don't put it anywhere. And so they're going to have to seek the court's approval for them to just be authorized to even find out what you have. And then there's all sorts of duties involved, right? Like determine who the creditors are, determine, what the inventory is of the assets that you left behind and the value of those assets. And with real estate, we all know, right? Real estate appreciates substantially, and the assets could definitely have kicked you into estate tax issues. So then they're going to have to determine the estate tax consequences, determine if there's a tax form due within 9 months of your passing. And guess what? The court proceedings are not going to be done in 9 months. So there's so much that's at issue here. And they might not qualify. Like the person that you might have trusted to be around and said, this is probably a person that would raise their hand and take action. Maybe my wife, maybe my brother, maybe my cousin. They might not qualify. They might not be able to afford the bond, which is usually like 1% of the value of the assets that you left behind. And the court's going to require a bond. They might not qualify as being close enough related to you if there's residency requirements in the state to be a personal representative or an executor. They might not meet the qualifications regarding the background check and not having felonies. Like here in the state of Florida, you can't have a felony and be a personal representative, even if it was 20 years ago. So there's so many little details that go into it that what might happen is that effectively everything comes to a standstill. Nobody can do anything. Nobody can afford it because here the usual cost of probate litigation, and this is uncontested, so nobody's fighting, but the usual cost is about 6% of the assets of the estate. Oh, wow. So imagine coming up with that. And so things just get lost, right? Eventually, somebody stops paying on the mortgages that you had on your assets. Somebody stops paying property taxes, right? Because they don't have the right to access. Why are they going to pay on them? And these things get foreclosed and they get, sold for tax or non-payment of taxes. And very quickly, the empire you built disappears. And the things that you thought you had set aside for your children, your spouse, your loved ones, they're gone. And that's the real problem with not having an estate plan in place. And also with this thinking that, oh, I'm young, I'm fine. Mm-hmm. There's nothing that says, because you're 30, you're okay. I've had partners who were in their 30s and had brain cancer. So this isn't a guarantee, right? Life is not guaranteed. And it is our responsibility as business owners and as parents to have that part organized too.
So how is that solved with a trust then? What would a trust do to resolve that issue?
So it's not so much the trust itself, but what you do with it, right? Because I've seen plenty of people that they go and maybe they download a trust online, or they went to a cheap firm that's like, oh, I'll prepare a trust instrument for you for $400, $500. And it never got funded, meaning you never actually transfer title of those assets into the trust. So guess what? You have expensive paperweight. It has absolutely no use if it's not funded. So assets must be retitled into the trust in order to keep them out of probate. Otherwise, it's the same probate process. And it's also about understanding like who you're putting into the roles of successor trustees, right? Is it somebody you trust? Is it somebody that's organized? Maybe if you don't have somebody like that, do you have a professional trustee that, you know, you've contracted with to take on that role? But having a trust that's properly funded, things are no longer held in the name of an individual, and therefore things are no longer part of a person's estate at death because they're now part of this private entity called a trust. So
I think a big mistake people make when they approach their business is they see it like all their other assets. And I get this a lot, which is, you know, what's the big deal? It's just going to work itself out at the end. And the answer to that is, to some extent, yeah, it's going to work out. You know, it's going to work out one way or the other. It might not benefit your heirs or what you would have wanted to happen, but with enough time, lawyers will find a way and get some of those assets. But a business is not like just shares of stock in a publicly traded company that might go up and down here or there, or your real estate that might continue to maintain some tangible value while you wait. A business is something where its lifeblood is cash flow. And when you put the brakes on and stop it from acting because there's nobody to be able to act on behalf of the business, now you've got what was a significant asset quickly losing value over time, or falling into what you were talking about before, kind of insolvency, where, you know, it's now losing real estate because it can't act. A business's ability to move forward requires the ability to act. And it seems to me that the trust or the proper structure and thinking through those allows continuity of the business regardless of what happened to me, the idea person, the owner originally. Do you think that's I'm on there, or you think I'm missing it?
No, I think you're right. And, you know, part of it, again, that's why I say like estate planning is really a strategy. It's not so much like focusing on this doc or that doc, but it's how they all work to support what you actually want to happen. And, you know, it's not just I've placed my business in a trust, but it's also, can my business qualify to immediately be transferred to a trust? Like if I have a business that's got an S election as its tax structure, do I have the right language in that trust to even be able to hold on to an S election entity without losing the S election, right? So there's these little nuances that really go into play when you're a business owner that you just need to be mindful of in planning. Other types of strategies are, do you have management agreements in place where maybe you've contracted with an entity to be the successor manager, because entities don't pass away. You know, have you authorized an agent under power of attorney to step in and be the immediate actor for certain parts of your business, you know, doing either operations or the administrative side, so that if anything does happen to you, there it is, there's somebody there. So it's all about like having a robust system that authorizes other individuals or entities to step up and make sure that, yes, the operations continue and that this asset that you created isn't all of a sudden worthless because nobody can act and it's frozen. Mm-hmm.
All right. You mentioned before, a part of estate planning is, and oftentimes, especially if you're dealing with businesses, is going to include entity structuring and so on and so forth. I wanted to bring that up because one common question I get almost at the beginning of, it usually doesn't start as an estate planning consultation. It starts as, I'm trying to shield my assets from liability conversation. And they say, all right, Andy, I need you to do a trust. I need full liability protection. We're going to put everything in the trust. I'm going to be good, right? Does a trust protect the settlor or the trust creator's assets?
So I'm gonna tell you the legal answer that we all know, right? It depends. It depends because, number one, right, we often get the phone calls of people that are like, I want to create a trust instrument now because I'm in the middle of litigation. And at that point, it's like, you're too late, right? If you're going to use trust vehicles to protect your assets, you cannot wait until you've been served with a letter of demand or a lawsuit. It's too late to transfer assets now. Okay. Fraudulent Transfers Acts of pretty much every state in the country will claw back those assets that you try to put into a trust. So that's number one. Number two, not every state allows what we call self-settling trusts. Okay, so these are trusts where the grantor is also the beneficiary of the trust, and it's trying to shield the assets of the grantor from the creditors of the grantor. In Florida, for example, self-settled trusts are not allowed. So you've got to be mindful of those things. The other thing is that even if you are in a state that allows for these self-settling trusts, so trust vehicles that can protect your assets, and by the way, revocable trusts do not do asset protection for grantors because they're revocable. They're seen as you in an alter ego form. So because you have the rights to put assets back and forth and all that, there's no creditor protection for you, the grantor there. There can be creditor protection for your beneficiaries, different beneficiaries, right? Your children, your nephew, your nieces, the people that are not the creators of the trust. But if you are in one of those states that allow self-settling trusts, where you can be a beneficiary of the trust that you created and get some creditor protection, that doesn't mean that you're necessarily going to be protected from the most powerful creditor that we face if we're U.S. citizens or U.S. residents, which is the IRS. The IRS has really, really high standards for the behavior that has to take place in order to protect those assets from the hands of the Internal Revenue if you have liabilities to the Internal Revenue.
So, and this is a little off topic as far as estate planning for businesses, but since we all represent investors, I thought I would throw it out there. In Florida, are land trusts popular?
Yes,
Okay.
They're extremely popular. So just to let everybody know, right, there's 5 states in the country that allow for land trusts. Florida is one of them. So there's statutory trusts in which you place interests in real estate. So it's not just land itself or a building. You can put in easements, you can own mortgage interests, any sort of an interest in land, leases, etc. And these trusts are designed so that neither the trustee can have personal liability nor the beneficiaries of the land trust can have personal liability for what takes place on the premises or relating to the asset that's held by the land trust. This is an asset protection vehicle that is a limited grantor asset protection vehicle. It is very unique, but again, there's only 5 states in the country that allow it. Very popular with real estate investors here. Yes.
Well, and I can see why, because we don't have that in Arizona, nor do we have it in Wisconsin, where I'm licensed. And and I'm actually I'm going to ask about this a little bit because I'm really curious. So on the land trust in Florida, let's say that the property's put into this land trust. So, you know, the person putting it in and that created the land trust is the grantor, the settler of the trust. Does the land trust and the property remain liable for the debts and obligations of the grantor settler, or are they separate at that point once the property is put into that land trust?
So it's treated as separate and distinct. And this is just because it's a creature of statute, right? It's not a traditional trust under the common law. So the statute itself has, by the goodness of the Florida legislature, created a little exemption where this asset is now isolated. It no longer belongs to the grantor. It belongs to the trust itself. And anything that's distributed as a profit resulting from the assets, that would be accessible to the beneficiaries of the trust creditors. But until and unless such a distribution is made, it's kind of left in there. Much in the same way of a limited liability company works. When you have a charging order. So it's like a hybrid private LLC for real estate assets, if I were to define it.
And can that be used outside? Do you know if that can be used outside of Florida? If it's created in Florida, can I then use it in? Oh, really? So
yeah, you can buy real estate anywhere in the world, actually, where assets are allowed to be held by trusts. So your Florida land trust can own real estate in Barbados if Barbados allows ownership through land trusts. And
you form land trusts or create land trusts, help clients? Oh, good to know. Oh, well, this is huge. I did not realize Florida has this particular statute. Very cool.
What makes that statute distinct? Well, let me back up. Is there anything stopping me in a general estate plan from using that trust because I like the asset protection vehicle and as a normal revocable living trust in my estate plan? Does it have to own real estate to qualify under that statute?
So it has to own real estate interests. Yes.
Okay.
Yes.
So if I have in a general Florida estate plan where, boy, everybody's usually going to have a home, maybe their primary residence or whatever else, are they opting to create a trust under that statute?
So if they have investment property or like sources of income related to real estate investments, like for example, hard money lender, right? They can own those separately through individual land trusts to kind of isolate those assets so that they're not something that belongs to the entirety of the revocable trust instrument, not being held directly by that. I don't recommend putting your homestead in a Florida land trust. And the reason why is because why do you want to lose homestead status and homestead tax exemptions and all those other benefits, right? This is for investments. Because here in Florida, we already have constitutional protections for homestead purposes. So
now one big ask, or the reason so many folks that Sean or I might meet with about land trust is based on the issue of anonymity. Does the Florida statute allow for anonymity within those trusts as well, or can that be achieved?
It's pretty much anonymous entities. They don't have to be recorded or registered anywhere. So it does have that benefit that pretty much is shared with other trust vehicles that are non-business trusts, because we do know that business trusts generally do have to register with the state. So Florida land trusts do not have to be registered anywhere. They can be kept private. And, you know, I often recommend that they use entities to be the trustees, entities that are not in easily visible states, right? Like Florida is a very sunshine, open state. You don't want to have a Florida entity be the trustee. Wouldn't make sense if you want to also control that trustee. So it's optimizing who you're placing in the trustee role, who you're using as a beneficiary, and they're also easy to manage in the sense that they're passed through for tax purposes. So that also limits being subject to subchapter J, which is what you see in more traditional trust vehicles. Yeah.
So it has to have its own tax ID number, though. No. Whose social security number does it use?
It's a revocable trust instrument, so it can use the beneficiary's tax ID. And depending on what you choose for it to be the beneficiary, right? You could have it be one of your other entities be the beneficiary that already has a tax ID.
So if people are wanting to use this, though, to convey real estate by swapping out the beneficial interest of the trust, then they just have to notify the IRS with the new social security number for the new beneficiary type of thing?
Yeah, pretty much. Okay. And it's also a very private way of transferring ownership and real estate interests without having to use a title company, without having to get a new recorded deed, right? Because then you just substitute the trustee. You record a substitution of the trustee appointment, and there you go. No reassessment, nothing else. Yeah.
Oh.
Sean, don't get any ideas. You're not moving to Florida. You've already moved to one state.
I'm all to Natalia. Everybody comes to me for a land trust. I'm like, you can't do, number one, even a Florida land trust in Arizona wouldn't work quite well because we have to disclose on the deed the beneficiaries and their addresses of every trust in and out of anytime you're transferring in or out of a trust. But I still have people come to me all the time. I'm like, why do you want to do a land trust? I didn't realize Florida has this specific statute that is awesome, because if we did it here in Arizona, with the lack of asset protection and stuff, it's like it just is a bad idea. But everybody go see Natalia for your land trust, and then you can own real estate throughout the nation using these Florida land trusts. It's amazing.
There you go. What about tax avoidance? Is your standard revocable living trust a tax avoidance vehicle?
It is certainly a tax minimization vehicle depending on your marital status. So you can have your revocable trust instrument if you're married, right? You can use it so that you optimize taking full advantage of the existing marital credit, right? Which depends on what citizenship status your spouse has, but you can make it so that there's no taxes owed at the death of the first spouse. You can make it so that there's stackability built in, so that, if you pass away and then your spouse passes away, now you've got a double credit stacked on top of the other to be able to use for your beneficiaries. So there are definitely some serious tax strategies. You can also, again, with blended families, make it so that you control what your spouse gets, your surviving spouse, while still being able to get the full credit, the full marital credit, even though your spouse didn't actually get all of your assets at death, because you wanted to make sure things were controlled and passed along to your heirs. So there's lots of unique features that you can build into a revocable trust instrument, Q-tips, Q-dots, if you're married to a non-citizen, non-resident, to minimize estate tax issues. If you're single, you've got a little bit less flexibility, and then you have to start thinking about irrevocable trust instruments to optimize gift tax credits. But yeah, there's some play with revocable.
Now, I want to talk about mistakes, and specifically with regard to business owners. What are the most common mistakes you see business owners make when it comes to their own estate planning?
All right, so I would say number one, not funding it. Meaning they get a trust, and they have not put a single one of their businesses to actually be part of the trust that they thought that they had for estate planning purposes. So number one is funding. Number two, it's failing to consider their tax elections and what they can shift and when into those trust vehicles. Like I said, it's a big and easy way to lose your S election if you put it into a trust that doesn't have the S language, or that has the wrong beneficiaries pursuant to the tax code. And that's 26 U.S. Code 1361 if you want to go look it up. And then not putting people or designating individuals in their entities to act as successor managers in case they're incapacitated or pass away. Like, you want to have it in your operating agreements already there, set up so that, bam, something happens to this person who's acting as manager, this other person immediately can step into the role and run the business, irrespective of you having passed.
So that's interesting. So the operating agreement, and we talked about buy-sell, which is a little different, but the actual operating agreement can have almost some estate planning characteristics, language provisions for succession. That's interesting. So besides managers, is there anything else you would want in your operating agreement that would deal with succession?
So I would and that's why I recommend, if you can, also set up individual management agreements, even if it's an agreement with yourself. Because what you want to have is a guideline of what you do in your business, so that this person that's a successor knows what to do, knows who to talk to, what your process is, what they should be checking, what the bank accounts are, who are the title companies that you use if you're a real estate investor, right? So that they know, and they're not at ground zero with zero assistance because they can't pick your brain. And then they can continue their operations, right? You want to have a guide in place. Management agreements generally are a lot more detailed. And what is this rule? What's this rule? What do I do here? What do I do there? And again, even if it's with yourself, you owe it to the person that's going to step into that role to understand how to run your business. As part of estate planning, I always tell my clients, if you're a business owner, you need to have a business plan that you work on annually, because that's also the other tool that your successor, manager, or officers are going to use to know how to optimize running your business for the sake of your beneficiaries.
So in creating that entity structure, I guess let's start with limited liability companies, which is probably the most common entity that you see used in small business estate plannings. You mentioned funding that. How does funding really happen in Florida when you're dealing with a small business and dealing with a trust? Is it just amending the articles of organization to place the trust as the trustees as the members? How do you like to set that up or see that set up?
So depending on, I start out first understanding what is your tax election, right? Because I don't want to impair that. And then there's certain assignments of interest that you can create. So most people that have a business have not created the actual membership shares. For those that are more familiar with like corporations, right? The stock, right? The physical thing that says this person owns this percentage as certified by the manager or by the officer or whatever. So once you know like what the tax aspects are of that particular entity, then you decide, is this going to be an assignment at death transfer? Okay, kind of like a joint bank account, or is this going to be an assignment now? You know, if they're like a partnership, then you can do an assignment now. If it's a pass-through entity and they're going to stick to pass-through, then you can do an assignment now. So usually it's done through an assignment of interest. Okay.
So following through also with you discussing really the importance of thinking about who's going to step in, even if it's yourself. How do you like to counsel small business owners, just the mom and pop business owners that have started the business, and it really is just themselves? How do you counsel them to start thinking through? Is it a question of who you hire and who you're going to mentor to eventually take over this role, seeing the business as potentially much bigger than it is? Because that's I would think a pretty hard thing, not hard to grasp, but hard to see, you know, your little business that you're excited about, but to think of it at the scale of having employees, and not just employees, of figureheads that would eventually take over. How do you counsel them through that to think through and plan for that?
So we usually start out with the counseling them on their individual financial things. Like, who in your life is there that you trust to be financially responsible, financially sound, that would be a good decision maker if you're incapacitated and need somebody to step up, right? They usually have 3 to 4 people in mind that they trust well enough to be able to step into that role. And from there, we say, okay, what kind of experience do these individuals have? What kind of time do these individuals have? What have you done as a business owner to put down the systems that you have in place for your business, to keep yourself organized financially, to make sure those P&Ls and all those other financial statements are up to date, so that somebody could step in and see it, you know, from a bird's eye view and go, okay, I have a general idea of like what I would need to do to run this business right now. And that's the process we run them through. And then they say, okay, I would be fine appointing this person as manager. I'd be fine appointing this person as, you know, successor officer here, or I have this professional, you know, the CPA for the company that I am going to make sure I introduce now to this family member, or to this friend that, you know, or this partner that I have in another business, but I know that they'd be great for this other business role. So it's all about helping them see who their resources are, and then who the professionals are that could support those other individuals and moving forward. Because, I mean, the reality is nobody is going to be you. And they just have to come to the acceptance of that, right? Nobody's going to be you. It's your job as a business owner to help them understand how you run your things and what's made you successful to get to that point of your business being an operating functional business that has revenues and, you know, maybe pay some taxes because it has profit. So that's how we do it. And it's also, you know, we've created a system where we have trainings for those people that get appointed for these roles, because otherwise they're going to be kind of like, I think I have to do this. I don't really know the roles. So we've created training videos for people that are going to be the successors. We've created training videos for some of the business aspects. We've created emergency business succession handbooks so that they know the information that they have to put down. And they have notebooks now that say specifically what they have to put down, so that when somebody steps into the role, they go, oh, yeah, like this is a bank account. These are their main vendors. These are their main suppliers. These are their main clients. This is all the contact information, and they're not left again at ground zero, just looking through rubble.
What about unique estate planning strategies and entity structuring that you've seen or maybe even employed for real estate investors that you like, you love, you think is a great idea, but you're not seeing it used, or people, maybe they're not planning on the front end, so they're doing it wrong on the front end? Have you seen anything that you really like that people are just missing?
So I want to bring up, that like the entity structure is very good for liability, but making sure that you plug the holes of it being you rather than a trust vehicle as the underlying actor. It also depends on like taxes, right? For example, when you pass away, the assets held in a revocable trust or held in your name personally get a step up in the basis, a step up in the value. So if you bought something for $50,000, but you died and it was worth $500,000, your beneficiaries, if it's in a revocable instrument, get the step up so that now their basis is $500,000, which really helps for capital gains tax purposes. You can also do this with certain types of partnerships, which is why family limited partnerships are a tool that's used for families that definitely know that they're up there in the estate tax bracket and want to use certain vehicles where, like this person's kind of gotten older and now they want to pass it along to their kids. Their kids are getting to know the business and all of that. So they become part of this family limited partnership, private entity. And that also gets a different step up in basis based on subchapter K of the tax code. So 754 allows a different step up in basis for those assets if the partner died. So again, it's a way to do you want to minimize capital gains of the assets that belong to your trust or the assets that belong to your partnerships, if you have partnerships? Or are you okay with maybe them having to deal with capital gains tax consequences in the future, but minimizing your estate tax now by using irrevocable instruments where it's like these assets, right? They're very highly appreciating assets, but I don't want them to be counted as part of my estate. I have too much. So I'm going to transfer this now to an irrevocable trust now that we have a huge tax credit, which sunsets in 2026. And do I want to be, in this separate thing that doesn't get counted as part of my assets, won't get counted as part of my estate, and will grow without me having to worry about estate tax consequences? Now, my beneficiaries will eventually have to worry about the capital gains tax issues, but that'll come for them at a later point. So it's what's important to you that really matters as to what tools that you use. But I think the family limited partnership is an underused one because people just don't understand that this is a way to play around with partnership law to get a step up in basis rather than the estate tax code to get a step up in basis. Yeah.
Interesting. Well, Natalia, this has been really good information. We really appreciate you taking the time. Tell our listeners how they can find and connect with you.
Absolutely. So you can find our website at www.lcolawfl.com. Our phone number is 813-480-2106. And you can reach out to my team by emailing clientcare@lcolawfl.com.
All right. And if you're watching, we'll also have Natalia's information in the description of the video. Natalia, thanks again so much for joining us. Let's do it again.
Thank you, gentlemen. Happy to be here.
All right. With that, everybody, that is our episode. Make sure to join us this afternoon for the collective, and we will see you next week.
Have a good day, everyone.